Book 1. Title 4. Local School Boards. Section 98. Creation, Composition, and Compensation. A. There shall be established in every province, city, or municipality a provincial, city, or municipal school board, respectively. B. The composition of local school boards shall be as follows. 1. The provincial school board shall be composed of the governor, and the division superintendent of schools as co-chairman. The chairman of the education committee of the provincial board, the provincial treasurer, the representative of the SK Federation in the provincial board, the duly elected president of the provincial federation of parents teachers associations, the duly elected representative of the teachers organizations in the province, and the duly elected representative of the non-academic personnel of public schools in the province, as members. 2. The city school board shall be composed of the city mayor and the city superintendent of schools as co-chairman. The chairman of the education committee of the city council, the city treasurer, the representative of the SK Federation in the city council, the duly elected president of the city federation of parents teachers associations, the duly elected representative of the teachers organizations in the city, and the duly elected representative of the non-academic personnel of public schools in the city, as members, and 3. The municipal school board shall be composed of the municipal mayor and the district supervisor of schools as co-chairman. The chairman of the education committee of the municipal council, the municipal treasurer, the representative of the SK Federation in the municipal council, the duly elected president of the municipal federation of parent-teacher associations, the duly elected representative of the teachers' organizations in the municipality, and the duly elected representative of the non-academic personnel of public schools in the municipality, as members. C. In the event that a province or city has 2 or more school superintendents, and in the event that a municipality has 2 or more district supervisors, the co-chairman of the local school board shall be determined as follows. 1. The Department of Education, Culture, and Sports shall designate the co-chairman for the provincial and city school boards, and 2. The Division Superintendent of Schools shall designate the district supervisor who shall serve as co-chairman of the municipal school board. D. The performance of the duties and responsibilities of the above-mentioned officials, in their respective local school boards, shall not be delegated. Section 99. Functions of local school boards. The provincial, city or municipal school board shall a. Determine, in accordance with the criteria set by the Department of Education, Culture, and Sports, the annual supplementary budgetary needs for the operation and maintenance of public schools within the province, city, or municipality, as the case may be, and the supplementary local cost of meeting such needs, which shall be reflected in the form of an annual school board budget, corresponding to its share of the proceeds of the special levy on real property constituting the Special Education Fund, and such other sources of revenue as this code and other laws or ordinances may provide. B. Authorize the provincial, city or municipal treasurer, as the case may be, to disburse funds from the Special Education Fund pursuant to the budget prepared, and in accordance with existing rules and regulations. C. Serve as an advisory committee to the Sanggunians and concerned on educational matters, such as, but not limited to, the necessity for and the uses of local appropriations for educational purposes, and D. Recommend changes in the names of public schools, within the territorial jurisdiction of the local government unit, for enactment by the Sanggunians and concerned. The Department of Education, Culture, and Sports, shall consult the local school board, on the appointment of division superintendents, district supervisors, school principals, and other school officials. Section 100. Meetings and Quorum, Budget. A. The local school board shall meet at least once a month, or as often as may be necessary. B. Any of the co-chairmen may call a meeting. A majority of all its members shall constitute a quorum. However, when both co-chairmen are present in a meeting, the local chief executive concerned, as a matter of protocol, shall be given preference to preside over the meeting. The division superintendent, city superintendent or district supervisor, as the case may be, shall prepare the budget of the school board concerned. Such budget shall be supported by programs, projects, and activities of the school board for the ensuing fiscal year. The affirmative vote of the majority of all the members, shall be necessary to approve the budget. C. The annual school board budget, shall give priority to the following. 1. Construction, repair, and maintenance of school buildings and other facilities of public elementary and secondary schools. 2. Establishment and maintenance of extension classes where necessary, and 3. Sports activities at the division, district, municipal, and barangay levels. Section 101. Compensation and Remuneration. The co-chairman and members of the provincial, city or municipal school board, shall perform their duties as such, without compensation or remuneration. Members thereof who are not government officials or employees, shall be entitled to necessary traveling expenses and allowances, chargeable against the funds of the local school board concerned, subject to existing accounting and auditing rules and regulations. Title V. Local Health Boards. Section 102. Creation and Composition. A. There shall be established a local health board in every province, city, or municipality. The composition of the local health boards shall be as follows. 1. The Provincial Health Board, shall be headed by the Governor as Chairman, the Provincial Health Officer as Vice Chairman, and the Chairman of the Committee on Health of the Provincial Board, a representative from the private sector or non-governmental organizations involved in health services, and a representative of the Department of Health in the province, as members. 2. The City Health Board, shall be headed by the City Mayor as Chairman, the City Health Officer as Vice Chairman, and the Chairman of the Committee on Health of the City Council, a representative from the private sector or non-governmental organizations involved in health services, and a representative of the Department of Health in the city, as members, and 3. The Municipal Health Board, shall be headed by the Municipal Mayor as Chairman, the Municipal Health Officer as Vice Chairman, and the Chairman of the Committee on Health of the Municipal Council, a representative from the private sector or non-governmental organizations involved in health services, and a representative of the Department of Health in the municipality, as members. B. The functions of the local health board shall be 1. To propose to the Sanggunians concerned, in accordance with standards and criteria set by the Department of Health, annual budgetary allocations for the operation and maintenance of health facilities and services within the municipality, city or province, as the case may be. 2. To serve as an advisory committee to the Sanggunians concerned on health matters, such as, but not limited to, the necessity for, and application of, local appropriations for public health purposes, and 3. Consistent with the technical and administrative standards of the Department of Health, create committees, which shall advise local health agencies on matters, such as, but not limited to, personnel selection and promotion, bids and awards, grievance and complaints, personnel discipline, budget review, operations review and similar functions. Section 103. Meetings and Quorum. A. The board shall meet at least once a month, or as may be necessary. B. A majority of the members of the board, shall constitute a quorum, but the chairman or the vice chairman must be present, during meetings where budgetary proposals are being prepared or considered. The affirmative vote of all the majority of the members, shall be necessary to approve such proposals. Section 104. Compensation and Remuneration. The chairman, vice chairman, and members of the provincial, city or municipal health board, shall perform their duties as such, without compensation or remuneration. Members thereof who are not government officials or employees, shall be entitled to necessary traveling expenses and allowances, chargeable against the funds of the local health board concerned, subject to existing accounting and auditing rules and regulations. Section 105. Direct national supervision and control by the Secretary of Health. In cases of epidemics, pestilence, and other widespread public health dangers, the Secretary of Health may, upon the direction of the President, and in consultation with the local government unit concerned, temporarily assume direct supervision and control over health operations, in any local government unit for the duration of the emergency, but in no case exceeding a cumulative period of 6 months. With the concurrence of the local government unit concerned, the period for such direct national control and supervision may be further extended. Title VI. Local Development Councils. Section 106. Local Development Councils. A. Each local government unit shall have a comprehensive multi-sectoral development plan, to be initiated by its Development Council, and approved by its Sanggunian. For this purpose, the Development Council at the provincial, city, municipal, or barangay level, shall assist the corresponding Sanggunian in setting the direction of economic and social development, and coordinating development efforts within its territorial jurisdiction. Section 107. Composition of Local Development Councils. The composition of the Local Development Council shall be as follows. A. The Barangay Development Council shall be headed by the Punong Barangay, and shall be composed of the following members. 1. Members of the Barangay Council. 2. Representatives of non-governmental organizations, operating in the barangay, who shall constitute not less than 1/4 of the members of the fully organized council, and 3. A representative of the congressman. B. The City or Municipal Development Council shall be headed by the mayor, and shall be composed of the following members. 1. All Punong barangays in the city or municipality. 2. The chairman of the Committee on Appropriations of the City Council or Municipal Council concerned. 3. The congressman or his representative, and 4. Representatives of non-governmental organizations, operating in the city or municipality, as the case may be, who shall constitute, not less than 1/4 of the members of the fully organized council. C. The Provincial Development Council shall be headed by the governor, and shall be composed of the following members. 1. All mayors of component cities and municipalities. 2. The chairman of the Committee on Appropriations of the Provincial Board. 3. The congressman or his representative, and 4. Representatives of non-governmental organizations, operating in the province, who shall constitute not less than 1/4 of the members of the fully organized council. D. The local development councils may call upon any local official concerned, or any official of national agencies or offices in the local government unit, to assist in the formulation of their respective development plans, and public investment programs. Section 108. Representation of non-governmental organizations. Within a period of 60 days from the start of organization of local development councils, the non-governmental organizations shall choose from among themselves their representatives to said councils. The local Sanggunian concerned shall accredit non-governmental organizations, subject to such criteria as may be provided by law. Section 109. Functions of Local Development Councils. A. The provincial, city, and municipal development councils shall exercise the following functions. 1. Formulate long-term, medium-term, and annual socio-economic development plans and policies. 2. Formulate the medium-term and annual public investment programs. 3. Appraise and prioritize socio-economic development programs and projects. 4. Formulate local investment incentives, to promote the inflow and direction of private investment capital. 5. Coordinate, monitor, and evaluate the implementation of development programs and projects, and 6. Perform such other functions, as may be provided by law or component authority. B. The Barangay Development Council shall exercise the following functions. 1. Mobilize people's participation in local development efforts. 2. Prepare barangay development plans based on local requirements. 3. Monitor and evaluate the implementation of national or local programs and projects, and 4. Perform such other functions, as may be provided by law or competent authority. Section 110. Meetings and Quorum. The Local Development Council shall meet at least once every 6 months, or as often as may be necessary. Section 111. Executive Committee. A. Each local development council shall create an executive committee to represent it, and act in its behalf when it is not in session. The composition of the executive committee shall be as follows. 1. The executive committee of the Provincial Development Council shall be composed of the governor as chairman, the representative of component city and municipal mayors to be chosen from among themselves, the chairman of the Committee on Appropriations of the Provincial Board, the president of the Provincial League of Barangays, and a representative of non-governmental organizations, that are represented in the council, as members. 2. The executive committee of the City or Municipal Development Council shall be composed of the mayor as chairman, the chairman of the Committee on Appropriations of the Provincial Board, the president of the City or Municipal League of Barangays, and a representative of non-governmental organizations that are represented in the council, as members, and 3. The executive committee of the Barangay Development Council shall be composed of the Punong Barangay as chairman, a representative of the Barangay Council to be chosen from among its members, and a representative of non-governmental organizations, that are represented in the council, as members. B. The executive committee shall exercise the following powers and functions. 1. Ensure that the decision of the council are faithfully carried out and implemented. 2. Act on matters requiring immediate attention or action by the council. 3. Formulate policies, plans, and programs based on the general principles laid down by the council, and 4. Act on other matters that may be authorized by the council. Section 112. Sectoral or functional committees. The local development councils may form sectoral or functional committees to assist them in the performance of their functions. Section 113. Secretariat. There is hereby constituted for each local development council a secretariat which shall be responsible for providing technical support, documentation of proceedings, preparation of reports, and such other assistance as may be required in the discharge of its functions. The local development council may avail of the services of any non-governmental organization, or educational or research institution for this purpose. The secretariats of the provincial, city, and municipal development councils shall be headed by their respective planning and development coordinators. The Secretariat of the Barangay Development Council shall be headed by the Barangay Secretary, who shall be assisted by the city or municipal planning and development coordinator concerned. Section 114. Relation of local development councils to the Sanggunian and the Regional Development Council. A. The policies, programs, and projects proposed by local development councils shall be submitted to the Sanggunian concerned for appropriate action. The local development plans approved by their respective Sanggunian may be integrated with the development plans of the next higher level of local development council. B. The approved development plans of provinces, highly urbanized cities, and independent component cities shall be submitted to the Regional Development Council, which shall be integrated into the Regional Development Plan for submission to the National Economic and Development Authority, in accordance with existing laws. Section 115. Budget Information. The Department of Budget and Management shall furnish the various local development councils information on financial resources and budgetary allocations applicable to their respective jurisdictions, to guide them in their planning functions. Title 7. Local Peace and Order Council. Section 116. Organization. There is hereby established in every province, city and municipality, a local peace and order council, pursuant to Executive Order No. 309, EO No. 309, as amended, Series of 1988. The local peace and order councils shall have the same composition and functions as those prescribed by said executive order. Title 8. Autonomous Special Economic Zones. Section 117. Establishment of Autonomous Special Economic Zones. The establishment by law of autonomous special economic zones in selected areas of the country shall be subject to concurrence by the local government units included therein. Title 9. Other provisions applicable to local government units. Chapter 1. Settlement of boundary disputes. Section 118. Jurisdictional responsibility for settlement of boundary dispute. Boundary disputes between and among local government units shall, as much as possible, be settled amicably. To this end, a. Boundary disputes involving two or more barangays in the same city or municipality shall be referred for settlement to the city council or municipal council concerned. b. Boundary disputes involving two or more municipalities within the same province shall be referred for settlement to the provincial board concerned. c. Boundary disputes involving municipalities or component cities of different provinces shall be jointly referred for settlement to the Sanggunians of the provinces concerned. d. Boundary disputes involving a component city or municipality on the one hand, and a highly urbanized city on the other, or two or more highly urbanized cities, shall be jointly referred for settlement to the respective Sanggunians of the parties. e. In the event the Sanggunian fails to effect an amicable settlement, within 60 days from the date the dispute was referred thereto, it shall issue a certification to that effect. Thereafter, the dispute shall be formally tried, by the Sanggunian concerned, which shall decide the issue within 60 days from the date of the certification referred to above. Section 119. Appeal. Within the time and manner prescribed by the rules of court, any party may elevate the decision of the Sanggunian concerned, to the proper regional trial court having jurisdiction over the area in dispute. The regional trial court shall decide the appeal, within 1 year from the filing thereof. Pending final resolution of the disputed area prior to the dispute, shall be maintained and continued, for all legal purposes. Chapter 2. Local Initiative and Referendum. Section 120. Local initiative defined. Local initiative is the legal process, whereby the registered voters of a local government unit may directly propose, enact, or amend any ordinance. Section 121. Who may exercise? The power of local initiative and referendum may be exercised by all registered voters of the provinces, cities, municipalities, and barangays. Section 122. Procedure in local initiative. A. Not less than 1,000 registered voters in case of provinces and cities, 100 in case of municipalities, and 50 in case of barangays, may file a petition with the Sanggunian concerned proposing the adoption, enactment, repeal, or amendment of an ordinance. b. If no favorable action thereon is taken, by the Sanggunian concerned, within 30 days from its presentation, the proponents, through their duly authorized and registered representatives, may invoke their power of initiative, giving notice thereof to the Sanggunian concerned. c. The proposition shall be numbered serially, starting from Roman numeral 1. The Cumlec or its designated representative, shall extend assistance in the formulation of the proposition. d. 2 or more propositions may be submitted in an initiative. e. Proponents shall have 90 days, in case of provinces and cities, 60 days in case of municipalities, and 30 days in case of barangays, from notice mentioned in subsection B hereof, to collect the required number of signatures. F. The petition shall be signed before the election registrar, or his designated representatives, in the presence of a representative of the proponent, and a representative of the Sanggunian concerned in a public place in the local government unit, as the case may be. Stations for collecting signatures may be established, in as many places as may be warranted. G. Upon the lapse of the period herein provided, the Cumlec, through its office in the local government unit concerned, shall certify as to whether or not the required number of signatures has been obtained. Failure to obtain the required number defeats the proposition. H. If the required number of signatures is obtained, the Cumlec shall then set a date for the initiative, during which the proposition shall be submitted to the registered voters in the local government unit concerned, for their approval within 60 days from the date of certification by the Cumlec, as provided in subsection G hereof, in case of provinces and cities, 45 days in case of municipalities, and 30 days in case of barangays. The initiative shall then be held on the date set, after which the results thereof shall be certified and proclaimed by the Cumlec. Section 123. Effectivity of local propositions. If the proposition is approved by a majority of the votes cast, it shall take effect 15 days after certification by the Cumlec, as if affirmative action thereon had been made by the Sanggunian and local chief executive concerned. If it fails to obtain said number of votes, the proposition is considered defeated. Section 124. Limitations on local initiative. A. The power of local initiative shall not be exercised more than once a year. B. Initiative shall extend only to subjects or matters, which are within the legal powers of the Sanggunian to enact. C. If at any time before the initiative is held, the Sanggunian concerned adopts in toto the proposition presented, and the local chief executive approves the same, the initiative shall be cancelled. However, those against such action may, if they so desire, apply for initiative in the manner herein provided. Section 125. Limitations upon Sanggunians. Any proposition or ordinance approved through the system of initiative and referendum, as herein provided, shall not be repealed, modified or amended by the Sanggunian concerned, within 6 months from the date of the approval thereof, and may be amended, modified or repealed by the Sanggunian within 3 years thereafter by a vote of 3/4 of all its members. Provided, that in case of barangays, the period shall be 18 months after the approval thereof. Section 126. Local referendum defined. Local referendum is the legal process, whereby the registered voters of the local government units, may approve, amend or reject any ordinance enacted by the Sanggunian. The local referendum shall be held under the control and direction of the Cumlec, within 60 days in case of provinces and cities, 45 days in case of municipalities, and 30 days in case of barangays. The Cumlec shall certify and proclaim the results of the said referendum. Section 127. Authority of courts. Nothing in this chapter shall prevent or preclude the proper courts, from declaring null and void any proposition approved pursuant to this chapter, for violation of the Constitution, or want of capacity of the Sanggunian concerned to enact the said measure.